Generative AI. Everybody talks about it. But who's doing what? And what's going to happen? In this video podcast from Leuven Law Firm, where I head our media and entertainment team, I have with me today Professor in IT and Media Law at Copenhagen Business School, Søren Sandfeldt Jacobsen, to talk about generative AI and copyright.
Hello and welcome to this video podcast about copyright and technology, artificial intelligence mainly. And with me I have a guest invite. I'm very grateful for that. Søren Sandfeldt Jacobsen, professor at Copenhagen Business School in IT and Media Law. Mm-hmm. And as I said, we are going to have a chat about AI tools and copyright. And before going more into our discussion about the specific topics, for the listeners and viewers, I would just like to outline where we think we are in terms of these legal issues. Naturally, artificial intelligence is not a new thing. It's been around for a long time, even longer than many of us think. When you are a musician or an amateur musician, you've also made acquaintance with the tool, at least if you have an iPhone, called GarageBand. Is some kind of artificial intelligence. But the thing is that the development within this area has taken a huge step over the last couple of years, and with at least only the last 2 years, and a tremendous amount of new tools and much more capable tools. I read yesterday a LinkedIn article about a very new kid on the block called Udio that is supposed to be much better than all the other new music AI tools that can generate songs better than a lot of modern musicians. I've briefly checked it out, and you can create a New York pop song in Beethoven style and things like that. So there's a lot of tools, and of course the big issues, legal issues, are becoming more and more important to have knowledge about. But at this point, we have none. We have a lot of assumptions that we can look at. We can, from a Danish and European perspective, of course, look at the legislation in place here and court precedents in neighboring areas. In Denmark, we have some precedents in relation to information scraping and the limits to that that may be applicable also with respect to the lawfulness of using training data to AI tools. We have European legislation implemented in Denmark, the Digital Single Market Directive from a few years ago, which allows for data mining. And of course, we have the newly proposed AI regulation that has been approved in its current form by the European Parliament in March. So the process of having that before the European Council is imminent and can be, of course, be expected to enter into force in 2025. So there is some sort of framework that can give us an idea of where we are. And I think that the main issues, you can comment on that and add on, Søren. We think in terms of legal issues, copyright-wise, is the input, the training of the various AI tools. Is that lawful, using copyright-protected material without consent? And then, of course, the training in itself, and as a third element, the output based on a prompt from a user and what comes out of it. Mm-hmm. Those are the three elements where you can consider whether the transactions and the actions are lawful or not copyright-wise. And I would just start with giving a suggestion to the main principles that we can look at here, and then we will take the debate from there. But a position that's been argued is that training based on copyright-protected material is not legal. The use to train a tool to be able to use that body of copyright-protected work is not permitted because it is a use of copyright-protected work. So if you do not have consent, that would be illegal. Then, based on an illegal training, obviously if a user prompts the tool to create a product based on the illegal training, that will also be an illegal output. But that is, of course, in this very, if you will, one-to-one scenario. You can have multiple scenarios where the data is actually not all of it illegal that has been trained on, or where there is consent. And you can have, of course, various output depending on whether you ask the tool to create something with a lot of prompt info on your own, or just make something in style copy like the Beatles yesterday. So that of course is the framework and the position that as a starting point there may be a part of these tools that will be illegal if you do not have consent. And naturally, where we are right now, legislation has not been in place, at least not for as long as these tools have been trained. So with the new legislation where the text and data mining possibilities could make some of it lawful, then things may change, but at least there will be different issues depending on what has been trained and on how that is. And in Denmark, we do not have currently any pending litigation. Of course, we all know that in the US there is a major litigation with the New York Times having sued OpenAI for using of New York Times articles. And we know that in Denmark the Right Holders Alliance have taken initiative to stop various uses like a tool called Boost 3, but there is no, as such, current pending litigation, at least with the courts. There may be arbitrations we do not know about. No. So based on that and based on the assumptions I made, the big question from here is the use appears to be quite massive. Despite the uncertainty as to the lawfulness. What will we see happening from here on in Denmark and Europe? What is your expectations to what will happen?
Well, there's going to be so much happening, both on, I think, the legislative side. We will see that we probably will need more regulation. The AI regulation in itself is very overall, as some basic principles it established, very sound, and has a few lines on copyright, but not much. So it lays an overall, you could say, ethical groundwork for the future years. That's fine. But just like we have, as you mentioned, the text and data mining in the Digital Single Markets Directive, there will be other legislative acts, I'm totally sure, and also on national level to the extent that that's possible within the framework of the EU regulation. So on the legislative side, we'll see a lot of activity. That will be difficult in itself because politicians, parliaments, they have very difficult to understand, or we have too, but at least we're professionals and we work with it on a nearly daily basis. But it's very difficult for legislators to understand. And legislation takes time. and this is so fast developing, it's almost incredible. As you mentioned, there's new tool arising almost on a daily basis, and also the known system chat GPT, for instance, there's a new version, yearly, maybe twice a year, and it's just not just minor amendment, it's huge amendments. So this has a pace that is really tremendous. So legislator will try to keep up to speed with development, but probably more or less in vain often. And then we have the court cases, and they will be very decisive, both in this country and in the US, and of course from the European Court of Justice, because I think that's where we will see the details being dealt with. And there we also have the practical circumstances. And I think that's my first point here really is, and I think you will agree to that you already indicated it, the facts of the specific case will be very, very determining. Because what is actually happening in that black box? Well, what is it that it has been trained on, and can we evidence that? Can we provide documentation on what they worked with in the first place? Can we, and that will be very difficult in terms of the huge tech companies. Can we get them to disclose what's actually going on in there in the algorithms? Probably not. It's their Coke recipe. They will never give up the algorithm unless they're really, really forced to.
Yeah.
So in every part, the input phase, the training phase, and to some extent the output phase as well, because what was the prompt, and do we need a backlog of all the prompts so we can see if there's originality in the prompt? So we will need massive data in itself to document what actually is going on.
Yes.
And that will be very, very difficult. So not only the legal side, but again, we're pretty used to handling the legal issues, and we have seen these phenomena in copyright where new technology has pitched in every year almost for the past 25 years. So that's not new to us, to interpret copyright in light of modern events and to apply regulatory amendments. We can do that. But what I will be puzzled and a little bit afraid is to go into the black box, as I call it, and try to find out what are the facts of the case.
Yeah.
Do you agree?
Yeah, I do. And when you mention court cases, of course, in any jurisdiction, court cases take some time, and in some
you know that better than anyone. Yeah.
They take a long time, and then my question is twofold for that. One is, you have, of course, speedy procedures like injunctions. To my knowledge, there has been no efforts seriously to try and stop any of these in speedy procedures. As I mentioned, the Rights Holders Alliance has stopped the use of Books 3 in certain areas, but that was on a voluntary basis. But do you agree that in terms of having a speedy process like an injunction, it will be, tantamount to being able to provide evidence because of these black box issues, because you will not be able to make evidence what actually happens, and therefore you will not be able to demonstrate that it was an illegal training.
Exactly.
Of course, you can say that they have to prove that it was legal training because there may be assumptions, but that really is something that depends on what's actually in there. Again, so
these
you agree with that?
We'll probably see. I agree with you, and I agree that the injunction instrument, which of course we know for many years, copyright plays a huge role in copyright in those jurisdictions. I know, because of course it's a vital interest to stop this thing. Then we can talk about damages and all that stuff in terms of an ordinary trial case in future. But we need to stop it from happening now, and that's why it's so proven so worthy, that instrument. But poor judge, I just say these judges who are may often just single judges in courts sitting with an AI injunction case. How that could go on for weeks and weeks, maybe months. We have the same situation. We've had that for a long time in patent law, because then, of course, you can file an injunction as well, and there's the same importance when it comes to patent violations. But there we have seen they are so complex, these patent
but
cases.
At least they are with a limit of facts, because it relates to the patent.
Exactly.
This is why this is open-ended.
This is open.
So I think there's a big
good point.
Further issue here.
Yeah.
I forgot to mention presenting you that you're also chairman of the board of the Danish Radio and TV television board, and I'm saying that because that board has some authority to deal with various issues where you can authorize activity or not. And I'm just curious to hear your thoughts about, would you think it could be likely that in jurisdictions like Denmark or of course European level, that you could have some sort of controlling body or approving body when we're now focusing on the black box issue, if we at least could know that the training was legal, or that you have limited this engine to only drive 200 miles an hour, which is the speed limit, and you can only use the engine in that way, then could it be relevant, and do you think it would be possible and likely that there could be such bodies that would sort of be approval of this AI tool can be used?
I think that's a very interesting thought, and maybe you got a point there, because there might be a solution, and of course there's always the risk that you could create another bureaucratic monster, but it could be very practical because of certain facts. One being that this is a cross-border problem. So it doesn't, if you establish a board here in Denmark, well, most of them are not even under Danish jurisdiction, so it's very, very easy to bypass in any way. So what we've seen, and that's what we see, for instance, in the radio and television board, and which is we administer the AVMS directive from the EU, and within that directive's framework, that has been amended over the time, of course, and there we have seen an increased European cooperation. We have seen the Commission stepping in much more, not necessarily to decide cases, but to connect the national authorities and make sure that information from one country reaches another country. And if it's a cross-border case with cross-border dimensions, then there's a dialogue between the relevant authorities under management or supervision by the EU Commission. And it actually works pretty fine. Yeah. And we have some sanctions there where the Commission says, if necessary, we will step in and make sure that these are really sanctions that you can touch and you can feel. So I actually, and I think that maybe you could create a subcommittee with external professionals who can sort of maybe, hopefully without too much time, establish like, okay, here, this AI tool, we can't see any immediate threat. We give that a green sign. Use that until the court may say otherwise. And then, of course, in all countries, you know that this is safe too. So things may work that way, but of course, it's going to take time, us also to create such new bodies. But if we don't, it'll end up at the courts. And the courts, I know that because I'm a lawyer myself, so I can say, it's not the best cases, for most lawyers know absolutely nothing about this stuff. I hate to say it, and judges as well. You know more about judges than I do, but that's my opinion. That I'm afraid they don't really understand this. No. So the cases will also take a lot of time just to provide information and hearing and testimonials and expert opinions.
So, right. But there it is for legislators an idea, perhaps. Yeah,
maybe.
So I mean, so we can sum up that we know that there's going to be legislation, and there's going to be court cases, and there may be
that's good. That's good news for any attorney.
Any attorney, that's of course right. Yeah. And then it could be relevant to have one other mechanism that could sort of open up the transparency issue, the black box issue, so we could have a better way of having disputes on the more specific issues. And then just to conclude this as a final thing, even though one may say that the training is illegal or the training is legal, there will still be issues on the other hand with the output. On the other end, and depending on, as you were about to touch upon, the prompts and the prompts themselves, are they actually a work of art? Because you have a very good prompt.
Or do they have originality in themselves?
And what comes out, how is it used? Yeah. Is it actually just used one-on-one, or do you sort of amend it afterwards? A person, all that will make a different outcome as to whether there is a copyright infringement and a copyright for the.
So again, you have to know the whole case. I'm sorry, but you need to know every detail. And then there's one final thing I would say, and that's a kind of sensitive debate, but we need to have that debate as to what extent can and should the providers of AI systems, including the big tech, disclose their algorithms. I know that it's their kind of Coca-Cola recipe, and I respect that. I respect the right of property, of course. But within those limits, shouldn't it be able to create some kind, or at least more than we have today, transparency of what's going on in the black box? We've seen a little bit in that direction with the DSM directive, but it's very little. In certain aspects, they are obligated to provide information on this and that, but it's not near anything that comes to how does this thing work. You don't have to disclose the whole program and software, but just the basic of what's going on in there. Yes. I'm just saying, we need to have that debate. Otherwise, it's going to be mysterious. Yes. And if there's something we lawyers we hate, it's when things become mysteries. Rather bad news than news I don't know how to handle.
So and a kind of ingredients list, but not how you've used it. Well, on that note, I would say thank you very much, Søren, for taking time.
Anytime.
Yes, and I'm Christian also from Løve Law Firm in Denmark. Thank you very much for listening and looking into us. Bye.
This concluded the video interview with Professor Søren Sandfeldt Jacobsen, and subsequent to our chat, I had the privilege of attending the Danish Parliament's Commerce Commission's hearing on AI on 23rd of May, where I asked the panelists about a possible license arrangement as discussed. The main position seemed to be that the EU AI regulations, transparency requirements, hopefully will be self-regulating. The hearing is video recorded. You can find it on the Parliament's website, www.folketinget.dk. Thank you very much for listening in.